Welcome to my YouTube channel, Legal Information, Law Insights. I am Advocate Mukund Mahajan. In today's video, we'll discuss a landmark 2025 Supreme Court judgment that provides a clear and structured four-step formula under Section 482 of the Criminal Procedure Code, CrPC, replaced by Section 528 of the Bharatiya Nagrik Suraksha Sanhita, BNSS, 2023, for quashing criminal cases. This ruling sets a legal precedent for high courts across India on how to exercise their inherent powers when a person seeks to quash false or malicious criminal charges. Let us begin with the basic case information. Case details. Case title: Pradeep Kumar Kesarwani vs. State of Uttar Pradesh and Andhra. Case number: Criminal Appeal number 2813 of 2024. Date of judgment: 2nd September 2025. Bench: Honorable Mr. Justice J.B. Pardiwala and Honorable Mr. Justice Sandeep Mehta. Court: Supreme Court of India. Reportable: yes. Background of the case. In 2014, a woman filed a private criminal complaint against the appellant, Mr. Pradeep Kumar Kesarwani, alleging that he had sexually assaulted and deceived her around the year 2010. The complaint cited the following offences: Section 376 IPC Rape, now Section 63 of BNS, 2023. Section 417 IPC Cheating, now Section 318 of BNS, 2023. Section 506 IPC Criminal Intimidation, now Section 141 of BNS, 2023. After conducting an inquiry under Section 202 CrPC, now Section 223 BNSS, the magistrate took cognizance under Section 190 CrPC, now Section 210 BNSS, and issued process under Section 204 CrPC, now Section 225 BNSS. The accused then approached the Allahabad High Court with a petition under Section 482 CrPC, now Section 528 BNSS, seeking to quash the criminal proceedings, but the High Court refused to intervene. Aggrieved by this, he approached the Supreme Court. Arguments by the appellant, accused Mr. Kesarwani. The complaint was filed after an unexplained delay of nearly 4 years, raising doubts about its authenticity. The allegations were vague, lacked medical evidence or corroboration, and did not inspire confidence. Material evidence presented by the accused showed the complainant's inconsistent conduct, suggesting fabrication. The entire complaint was an abuse of process, aimed at harassing the accused. Arguments by the respondents, complainant and State of UP. The complainant claimed she was sexually assaulted and deceived, and deserved a fair trial. The state argued that disputed facts should be tested during trial, and not at the quashing stage. Delay, by itself, should not lead to quashing in serious offences like rape or cheating. Supreme Court's analysis. The Supreme Court reaffirmed the principle that Section 482 CrPC, now Section 528 BNSS, gives the High Court inherent powers to 1. Prevent abuse of the process of the court, 2. Secure the ends of justice. However, the court emphasized that these powers must be exercised with caution, and only in the rarest of rare cases where it is manifestly unjust to continue criminal proceedings. The four-step formula laid down by the Supreme Court. The Supreme Court introduced a structured four-step test for high courts to apply while considering quashing petitions under Section 482 CrPC Section 528 BNSS. Step 1: Quality of the accused's material. Whether the material relied upon by the accused is sound, reasonable, and of indubitable quality. The evidence must be sterling and impeccable, such that no serious challenge can be made against it. It must inspire confidence. Step 2: Contradiction of allegations. Whether such material would rule out the factual assertions made in the complaint or charge. If the accused's material, accepted as true, would make the allegations patently false, then it supports quashing. Step 3: Rebuttal by complainant or prosecution. Whether such material has not been refuted by the complainant prosecution or is such that it cannot be justifiably refuted. If the prosecution cannot meaningfully dispute the accused's material, or chooses not to, it strengthens the plea for quashing. Step 4: Abuse of process. No purpose of trial. Whether continuing the trial would amount to an abuse of the process of court and would not serve the ends of justice. If the criminal case is frivolous, vexatious, or based on malicious intent, the trial would waste court time and harass the accused. Application of the test in this case. The Supreme Court applied this 4-step test and observed. The 4-year delay in filing the complaint was not explained. The material presented by the accused was credible and compelling. The prosecution failed to refute or undermine this material. Allowing the trial would be an abuse of judicial process and would not achieve justice. Final judgment. The Supreme Court allowed the appeal, quashed the summoning order issued by the magistrate, terminated the criminal proceedings against Mr. Pradeep Kumar Kesarwani. The court clarified that the 4-step test should now be the guiding framework for all high courts in quashing matters under Section 482 CrPC Section 528 BNSS. Key takeaways. High courts must now systematically apply the 4-step formula before quashing cases. The ruling ensures innocent persons are not dragged into baseless criminal litigation. It maintains a balance between the rights of accused and the right to trial of victims. Closing remarks. This landmark judgment by the Supreme Court brings consistency and fairness to how high courts use their inherent powers to protect individuals from misuse of criminal law. Thanks for watching this video. If you found it informative, please like, subscribe, and share your thoughts in the comments. Don't forget to hit the bell icon for more legal insights. I will meet you in the next video soon. Jai Hind. Jai Bharat.